National Review's Charles Cooke reacts to the big Supreme Court gun ruling and the Senate bipartisan gun deal. That and more on this episode of the Weekly Reload Podcast.
I made the devil run. I gave him poison just for fun.
All right. Welcome, ladies and gentlemen, to another episode of the Weekly Reload Podcast. I'm your host, Stephen Gutowski. I'm also the founder of thereload.com, where you can head over and pick up a membership today if you want to get exclusive access to hundreds of pieces of analysis and stories that you cannot get anywhere else. You can also subscribe to our free newsletter if you want to see some of the work that we do before you make the dive into full membership. But members do get this podcast a day early, and they get the opportunity to appear on the podcast. We had a wonderful member last week, Mary Catherine Ham, on, and so you guys should check out that episode too. But this week, we got a lot of news. We got a lot of news to cover, and that includes the Supreme Court's decision in New York State Rifle and Pistol Association v. Bruen, which is the first major gun decision in over a decade from the court. And so joining me today is Charles Cooke from National Review, who has written extensively on the court and on this issue in particular. Thanks for being with us, Charles.
Thanks for having me. We actually set this up before we knew Bruen was coming down, so this is serendipitous.
Yes, it worked out well. We're also going to talk a little bit about the Senate gun deal, because that's the other big piece of news that's going on this week. We got a lot just dumped on us all at once here, but the Supreme Court case, I think you'd agree, is the bigger story at this point. What is your main takeaway?
Well, I think it does two things. The first thing it does is address what was a fairly narrow question, that being, can a state introduce into its application criteria for gun carry permits anything other than general objective rules? In other words, can a state say that an applicant needs to determine need as determined by a police officer or
judge,
officer of the state, or a judge, or can a state only impose regulations that affect everyone equally? You know, for example, are you a felon? Have you been convicted of domestic violence? Are you subject to a mental health order? And the court came down and said, if you're going to have a permitting system, many states don't, I think 25 states don't, but if you're going to have a permitting system, then you have to apply those permits evenly. But the second thing it did, which got, I think, slightly less attention, but in the long run is really going to matter, is it cleared up a lot of the loose ends from Heller. And it did so responsively, because a lot of the lower courts have proceeded since 2008 and 2010 with McDonald as if Heller never happened. They found ways to get around it. Heller didn't, for example, put a level of scrutiny in its ruling. So courts have made up their own. And what Thomas says in his majority opinion is, this is not an intermediate scrutiny right. This can't be treated differently than any other right. And the only thing you're allowed to look at is the text and the history.
Yeah, which I agree with you is going to be the much bigger impact here out of this ruling. Certainly, simply striking down New York's May issue, as it's called, gun permitting law for concealed carry, is significant because it impacts the remaining 7 or 8. My count was 8. The court's count is 7 for some reason. I'd have to look into which state they're not including, but those states are actually fairly large states, though. New York, California, Massachusetts, New Jersey. So that covers about 25% of the country's population. So it's even just that part is significant. But the new standard, or I guess clarifying the standard for how to decide Second Amendment cases moving forward, is obviously going to impact a lot more, because it'll be relevant in basically every gun case from here on out at the federal level, right?
Yeah. And also long before those cases get to the Supreme Court. which is the key, because Supreme Court cases are rare. Most of these issues will be litigated in the lower courts. And what Thomas did with the 5 other justices in the majority opinion is give pretty clear instructions as to how those lower courts have to proceed going forward. Now, he greatly irritated Justice Breyer in the process, but he did so on the back of a phrase we've heard a great deal from Clarence Thomas. That is that the Second Amendment is not a second-class right. He's been saying this for years when dissenting in the court's decisions not to take big gun cases. He thinks that its inability or unwillingness to take gun cases has relegated the Second Amendment to a second-class right. And here what he's saying is, well, now we've taken this case, we're not going to allow it to be treated as a second-class right either in this court or anywhere else. And he says in the opinion, look, we don't have a system where only some people get to take advantage of the First Amendment. We don't have a system where only some people have their privacy rights upheld. We don't have a system in which only some people get a trial by jury, and we can't have that in the Second Amendment either. And he's not inventing anything new there. What he's doing is complaining that the Heller decision did not put enough meat on the bone to preempt the lower courts into treating the Second Amendment as the right that the Heller decision correctly confirmed it to be.
Right. Yeah. And here's a quote directly from the majority opinion from Justice Thomas. He says, "The constitutional right to bear arms in public for self-defense is not a second-class right subject to an entirely different body of rules than other Bill of Rights guarantees. We know of no other constitutional right that an individual may exercise only after demonstrating to the government officials some special need." And so, that I think that sums up the New York case pretty well, because the whole idea of may issue laws is that not only do you have to pass the background check and the training requirements, but you also have to show that you have some sort of specialized good reason to need to carry a gun. And usually in most states with that rule, that means you have to have some sort of very specific threat against your life. You have to have a stalker or some sort of restraining order. And in some places, it's just a total fig leaf, like Hawaii, where they don't issue any gun carry permits. Not a single person in the state, I guess, apparently has a special need to carry a gun.
Right. And there's actually a footnote in the decision that is interesting that says that the court is not in any way questioning the capacity of a state. And it points to it says 43 states that have shall issue systems, that it's not questioning the ability of a state to, for example, have a permitting process, put a training requirement in, or what you will. But it does say that if the permitting system is used cynically, if it's used to delay concealed carry or open carry, if it's used as a prohibition mechanism, if it's used to treat people differently, then there can be a constitutional challenge on those grounds. And I think it's worth our saying here that, in a sense, this isn't just a Second Amendment question. I mean, the specific issue here is the Second Amendment as incorporated via the 14th Amendment. But this is also an equal protection question. We don't have a system in the United States where people can be treated subjectively differently under the law. That has been illegal, thankfully, for a very long time. And that's what New York's doing here. Anything objective is presumptively constitutional under this decision. If they say you have to fire 50 rounds before we'll give you a permit, if you have to take an NRA training course, you can't have a felony conviction, you have to be over 21, you have to have a permanent address, objective criteria, those are fine. And you probably will see some states now that will implement, pretty tough training requirements, say 16-hour classes and that sort of thing. What they can't do is create any system in which there is a subjective determination made by an officer of the government that could be made differently by another one, where Officer A says, I don't think you need it, but Officer B might say, well, I think you might need it. That is obviously not the case with felony convictions or certificates or that sort of thing. And I think that's a really good step for American law under equal protection grounds, leaving aside the question of the Second Amendment.
Yeah, good point. And just to reiterate on what you were saying earlier, Justices Brett Kavanaugh and John Roberts had a concurrence that sort of emphasized the fact that this doesn't strike down what are commonly called shall issue laws. And here's a quick quote from them. "The court's decision does not prohibit states from imposing licensing requirements for carrying a handgun for self-defense. In particular, the court's decision does not affect the existing licensing regimes, known as shall issue regimes, that are employed in 43 states. The court's decision addresses only the unusual discretionary licensing regimes known as may issue regimes that are employed by 6 states, including New York. So the count's a little weird. But anyway, and then they also reemphasize in both the majority opinion and this Kavanaugh concurrence that the Second Amendment is not unlimited, and that there are restrictions that are presumptively constitutional so long as they are longstanding and in accordance with the text of the Second Amendment. And that's important. But I want to talk real briefly here, because you kind of got into it a little bit, on the practical impacts of this ruling immediately. And so on gun carry in the United States, right? Most states are probably, you're not going to see any difference, right? Because most states don't have these laws. But in places like New York or California or Massachusetts, you're going to see a new set of rules for gun carry permits, right? And to me, it'll probably end up, as you alluded to there, a lot like what they have in Washington, D.C., where they just went through this process a couple of years before, a couple of years back, and now they have a shall issue law, but it's one that has much higher training requirements than most other states or jurisdictions, and one that has a lot more restrictions on where you can carry a firearm. So is that how you think this will play out?
Well, I think that the where you can carry a firearm question is going to be probably the next big issue. Thomas notes in his opinion correctly that at the time of the founding, there were time and place restrictions on the Second Amendment. And he says there's no reason to suggest there can't be time and place restrictions on the Second Amendment now. And he says, but at the time of the founding, if, for example, polling places were off limits for carry because they wanted to avoid the semblance of intimidation, whereas now we put schools off limit. And he says this is analogous. This is fine. What he objected to was the state of New York analogizing between, say, a polling place and all of Manhattan. Right. He says that is not a time and place restriction. That is a prohibition.
Right.
So that part, I think, will be slowly worked out. And obviously, the first thing that's going to happen is nothing, because this is not as if the court had come out and said, constitutional carry is mandatory. And so suddenly someone in California says, well, great, I can take a gun out with me, right, where I wasn't able to before. People are still going to have to apply for permits. And until they have a permit, they won't have a permit. And if they don't have a permit, they can't carry a gun. So, I mean, as of today, nothing's changed. It's not like that brief, was it 1 day, 2 days, where Washington, D.C., 3 days was constitutional carry.
Because I did it. I carried on the mall for that very brief period of time with the ruling in my pocket.
Right. I don't think that we're going to see much litigation in New York or New Jersey or California over what they choose to do. There will be a threshold somewhere. I mean, they can't charge $5,000 for a carry permit, or so you have to go through 2 years of training probably. But if they do what's happened in Washington, D.C., and they make it difficult, I think that will probably stand up under this decision and under this court's watchful eye. So, what will change? New York, New Jersey, California are gonna be more like Washington, D.C. There just won't be a component there that requires permission from a subjective actor. And then I would imagine a whole host of venues and jurisdictions are going to say you can't carry a gun here. And eventually that's going to lead to some litigation because they'll push it too far.
Yeah, that's probably what'll happen. I mean, DC has, DC's probably the strictest of the shall issue laws out there, because it requires 16 hours of training, including range time with that training, which you can't do in the city because there are no public shooting ranges there. So you have to travel outside. It's a similar thing to what they do with Chicago in Illinois. But it also has these, it has a lot of gun-free zones, of course. They make, you can't carry on public transportation, which obviously presents a lot of problems if you don't own a car. And then you also, they've created special gun-free zones. This has actually happened in Virginia recently as well, and a couple other states are doing this now with permitted events or events that ought to have been permitted. Protests, large gatherings of that nature, you can't carry there. And so you kind of have to, if you see too many people gathering in one place, you have to run away from them, I guess, is the idea. But, and then also DC has a special gun-free zone that travels. It follows diplomatic cars around. So if you see a diplomat coming towards you, run away, I guess. Again, now I believe they have to give you some sort of warning before you could be arrested over this, but you get the idea. There will be things like that, which will probably be contentious, that will come up in these new laws. But that's what I'd expect the direction of things to head. The
last thing to say here is that, despite the freak out that followed the announcement of this decision, and a statement from the president saying how disappointed he was, and the statement from the governor of New York, concealed carry really has very little to do with either mass shootings or daily crime.
Right.
It's just not. I mean, really, the only thing that concealed carry has to do with mass shootings is that very occasionally, a concealed carrier stops one, as we saw in West Virginia a month ago. That's it. Yes. And with day-to-day crime, the idea that the problem we have in America with crime committed with firearms is concealed carry, it's just ridiculous. The two really don't intersect. And what data we have out of Florida and Texas, is less reliable from Texas now because they have constitutional carry, but is that concealed carriers are about 6 or 7 times more law-abiding than the police. So, this decision is it's big, but it's not really even likely to intersect with our gun control debate. It's never been the problem. And that's why we've gone from may issue to shall issue to constitutional carry in a whole bunch of jurisdictions, and nothing has happened in either direction. Crime hasn't gone up or down as a result. It's just not really related. And, I think that's something that's worth remembering. It certainly comes up in the decision, because in the dissent, Justice Breyer lists this parade of horribles. He talks about shootings and suicides and crime, all of which are really important things we should talk about. And Justice Alito responds and sort of says, well, I don't really know what that's got to do with this. It's, no one who's committing a crime like that is worried that they can or can't take their gun outside. No one who's committing domestic violence is going to be dissuaded because the rules for carry have changed. No criminal. It just doesn't really intersect. And I suppose what we'll see is an attempt to link it to other events. But this is something that really stands alone when thinking about people abusing guns.
Yeah, and we've actually written about both of those things. The concealed carry crime rate, crime rate for people who have concealed carry licenses is infinitesimally small, even compared to police officers. And we had an analysis piece on that just recently at the Reload. And we also wrote up the FBI's active shooter report, which indicated that I believe there are 22 incidents where an armed civilian had shot the attacker. Now, active shooter is a little different than mass shooting, because an active shooting doesn't always turn into a mass shooting, obviously. But somebody with that sort of intention of shooting up a public area, that would be an active shooter in the FBI's estimation, and that's where you've seen at least some of them. It's not a huge percentage overall, but I think there were something like 700 in the report in the time period they looked at. But certainly it does happen sometimes. But yeah, anyway, I want to transition a little bit into the what exactly you think this new standard of review, or sort of clarified standard of review that the majority has put into this opinion, is going to result in. Like, what are the laws that you feel won't stand up to scrutiny under this standard?
Well, the first thing to say is that while the approach that the majority lays out makes it much more difficult for judges to put their thumb on the scale, you cannot stop courts from doing that if they really want to. And we saw this famously with the Fourth Circuit's decision on the so-called assault weapons ban in Maryland, where the court sort of said, well, this is a weapon that is unusual in nature, and therefore it doesn't qualify for Heller's in common use protection. And to sustain this, they said all sorts of things about the AR-15 platform that aren't true. And really, they were talking about, an M4 or some sort of select fire or, fully automatic weapon. And that hasn't been reviewed by the court. So, if a lower court really wants to play games with this, of course, what the majority opinion does is make it far easier for the court now to dismiss those arguments. It makes it more difficult for the lower court to ignore Heller because Heller is fleshed out. So, I think it's worth saying that this is not some magic fix, but it does make a difference. What do I think is going to happen? I think what Thomas has tried to do here is what Thomas should have done here, which is treat the Second Amendment as if it's actually a constitutional right. And, I've had this conversation with a lot of people who disagree with me on gun control. Forget the law, just on gun control as a political matter or a legal matter. And, they will say, well, yes, but, it's just different, isn't it? And, okay, yes, and certainly where I'm from it is, but if it's a constitutional right and we treat constitutional rights seriously, then no, it's not different. And I think what Thomas has tried to do is remove some of the avenues whereby judges are able to say, yeah, the Second Amendment, but this is just too important. And the most obvious effect that might have is if there is a case on, say, assault weapons, so-called, or high-capacity magazines, and providing that there is some analogy between those weapons and weapons of the founding, or the original definition of arms covers them, which I think it does. Contemporary definitions of arms in the 18th century explicitly mention carbines, for example, and the AR-15 is one. I think this makes it more difficult to ban those weapons outright. I don't suspect we're going to see a much stricter approach toward carry for the reasons I've already outlined. I think this is about as far as the court is going to go or should go. We already have the decision in Heller that lays out that the Second Amendment protects an individual right, and that the ban on handguns is unconstitutional, and so on. The next frontier is obviously, well, what's allowed and what's not. And this probably does make it more difficult for jurisdictions to ban those weapons. But the only caveat there is the Supreme Court seems to take one of these cases every 15 years. So
right.
I might be 50 by the time it happens.
That's exactly what I was saying. I think that's a very important point to make here. It does seem like under this new clarified standard, which really the court is just saying is the same standard they used in Heller, but they're kind of spelling it out now more explicitly. That a lot of laws that just are not long-standing, basically, if they came about starting in the 20th century, they might have a significant problem passing this new test. So yeah, assault weapons bans, magazine limits, gun sales permitting, perhaps, gun licensing, those sorts of things. You could see a lot of those face new scrutiny. But I think ultimately it does really boil down to, like, is the court going to actually take cases to enforce this new standard? Because that's been the problem up until right now, is that this is what everybody argued was the standard. Kavanaugh put it, sort of articulated it, I guess, in the most influential way. But But, the Heller standard on the gun rights side, this has been what people thought the court was saying the whole time. And it didn't really matter because the court wouldn't take any of these cases where lower courts upheld gun restrictions based on this two-step standard that
Right.
it has now trashed. So I think it will come down a lot to whether they actually take more cases, right?
Right. I think that's right. I think there's a couple of reasons that they haven't taken more cases. One has changed, the other hasn't. The first is obviously the makeup of the court. This is a different court than the one that decided Heller and that decided McDonald. So there's probably more votes now to take these cases, and there's
Right.
probably more confidence that if they take them, they will come out in a clear fashion.
Right.
The thing that hasn't changed is that some of these questions are actually really difficult. So I don't think that the case that the court looked at today was particularly difficult. I don't think Heller was particularly difficult. I do think it would be difficult for the court to start micromanaging this. For example, is 12 hours of training fine? Is 18 hours of training fine? Now, a year of training is too much. But, other than outlining broad strokes, you don't want to have every gun question being decided by judges.
Yeah.
And as such, I think some of the cases that people want them to take, including which weapons are allowed, are actually quite hard to deal with. Heller has an in common use standard. I think the AR-15 is very clearly protected. So this is in no way to undermine that idea. But there's also a provision in Heller that talks about unusual weapons. What is that?
Yeah,
that's tough. And I don't think they want to get too much into that, in the same way that in the 60s, they got tired of having to decide what pornography was and wasn't, and eventually said, we're not doing it anymore. Right.
I mean, and Heller, to me, it's still very much a compromise ruling. I mean, you've got, I just said that a lot of laws that didn't exist until the 20th century are going to come under new scrutiny because of the standard. But the court has already said something like the National Firearms Act, or alluded to the National Firearms Act in Heller, and said it was presumptively constitutional because it's, I guess, automatic weapons are unusual and dangerous, at least in it's not, it wasn't a major part of the ruling, but it was something that was mentioned as like, here are some laws that we don't think would be struck down by the Second Amendment. And the National Firearms Act, which didn't happen until 1934, was among them. So,
yeah, I mean, the problem with the in common use standard is, although I understand the logic for it, it can ultimately become circular, right? In the sense that, so tomorrow, let's say that somebody invents a smart gun. Now, we associate smart guns either with the sort of James Bond movies, because they don't really exist, or with Democratic politicians who are obsessed with them and they really want this to be the future, and they always talk about getting rid of all the guns that aren't smart guns and so on. But you could theoretically have a state that says, okay, well, the smart gun has just been invented that actually works. We're banning it. And under Heller's in common use standard, that might be all right. Yeah. Which, is that really what the Second Amendment is supposed to do? I don't know. That's a tricky one. So yeah, I take your point, but I think that really underscores the problem, which is that the court, I think, wants to get involved in broad brush decisions that make it clear what the Second Amendment means and what can, on a macro basis, be prohibited and what can't. And beyond that, I think it wants to leave the question to state and federal legislatures, and I think it's right to do so within bounds.
Yeah, no, I mean, the court shouldn't become its own legislature, right? That's goes very much against what a lot of pro-gun or conservative activists want. So I think you're absolutely right, and it will be interesting. I mean, look, Heller, to me, when I read through Heller, and when you read through this case, this opinion, like, Heller's trying to just get at one small thing, which is to establish that the Second Amendment applies to individuals, and that the handgun, which is the most popular gun for self-defense in the country, is something that is protected. That if the Second Amendment means anything, it must mean this thing. And so it's building from there. And, it's not going to be completely clean all the time with these sort of outcomes because, life is complicated. The law is complicated. There's a lot of balancing acts to do here. But so, I mean, still, this ruling does represent what everybody in the gun rights community wanted, I think, out of this case. The only thing I think that's missing, perhaps, on the gun carry aspect is, in D.C., when they struck down D.C.'s law, there was a specific provision that said that had to be D.C. had to accept non-resident applications for permits, and I don't believe that there's anything like that in this ruling. Is there?
No, there's nothing like that at all.
I didn't see it.
All this says, and it's funny because the concurrences from Kavanaugh and Alito are very keen to put this in its correct context. And Alito begins his concurrence by saying that so much of the effort undertaken in the dissent is to obfuscate the fact that this ruling is actually somewhat simple. And all it says is, if you have a permitting system, as opposed to, say, a state such as Texas that just allows anyone to carry a firearm, providing they're eligible, without a permit, then you can't hand them out on an unequal basis. That's it.
Yeah.
I mean, so the state of Virginia can say we don't accept a permit from the state of Florida. Quite easily, the state of Virginia can say you have to have a 20-hour course before you can have a permit. What it can't do is say you have to demonstrate to us that you need this more than anyone else. The presumption is that you have access to that right. And again, I that's because it's a right. I mean, this is ultimately our argument. And I was reading the dissents and I'm thinking, okay, I wish that Breyer and the others joined it. They didn't write, but I wish Breyer would just say that he doesn't think it's a right. Just openly say that. Because everything that flows from that position is consistent with his dissent. It's just, if you believe it's a right, and that's how I would characterize it, that Heller announced to the world once and for all that the Second Amendment protects an individual right, and Bruen has announced to the world once and for all that that right is to be treated like any other right in the Bill of Rights. That's what just happened.
Yeah, I think that's a pretty good summation at the bottom line of what exactly this ruling does. But I think we should probably move on real quick, just in the little time we have left here, to talk about the Senate. Because as this is happening, as the Supreme Court is releasing the major ruling on the Second Amendment, you also have a major development in federal gun legislation. For the first time in decades, you're getting new gun restrictions. It's not the first federal gun law, right? And I know you've written about this, so the way media has covered this, but it's the first time we have new restrictions. And frankly, the bill hasn't technically passed yet, but it's extremely likely to happen before the July 4th recess here that's coming up. And, it's the first one that has new restrictions, and that could apply to a lot of people, honestly, given the way the bill is written and the fact that it extends the current prohibitions on selling guns to somebody who has a felony conviction, a domestic violence misdemeanor, or has been involuntarily committed. It extends all those things to that person, to anyone's juvenile records in as well as their adult records. So that, I don't know how many people, I'm sure there's no way to really know for sure how many people that's going to make newly prohibited. But it's probably a lot, right?
Yeah. So I backing up a bit, I don't think this law is very good.
Yes, you've been critical. You've written a number of pieces at National Review on this. So, can you just give us your overarching view of why you don't think this deal is a good idea?
Well, I first off don't think it's a deal. I think it's a series of concessions, and I wish Republicans would stop calling it a deal. A deal would be where both sides have got something they wanted, rather than one side getting some of what it wanted. There are changes to the law that Republicans want. For example, they'd like to fix the Firearms Owners Protection Act. They'd like to take suppressors out of the NFA. They're never going to get something massive like concealed carry reciprocity, which I should say I have a constitutional issue with, which we won't go into now. But they could have got something around the edges that really would not have undermined what the Democrats are trying to do. They didn't. This isn't a deal. It's a concession.
Well, one, I guess, just to challenge you real quick on that point, they did get, funding for school safety programs and funding for mental health crisis interventions, which has been priorities for Republicans and even, groups like the NRA as, solutions to mass shootings. But you don't view that as there isn't any program.
I don't. Right? I don't, because I think that while the Republicans are the people who have said we need to make schools safer, I don't think it was ever necessarily the product of federal funding. That was their idea as to how they could do it. But schools are a state concern. I've never heard a Republican say, the way that we should fix this is to harden our schools, and it has to be with federal money. This is really a state question. So the way I see this bill, I think there's sort of three categories. One are ideas that really do belong to the states. Two is ideas that are actually already in federal law and are weirdly reiterated. And three is good federal ideas that are the federal government's job, but just don't seem to have been particularly well thought through. So in the first category, you have all sorts of money for what are really state concerns. You have money for red flag laws, money for mental health, money for hardening schools. I don't think that's the role of the federal government. I don't like the federal government spending money when it doesn't have any left. I don't like the federal government sending money to the states on average, because it adds all sorts of riders to the money that interferes with state prerogatives. So I don't think there was a need for federal money here. I don't think any state in the union has declined to implement a red flag system because they thought it would cost too much. To me, this is federal intrusion. Then there's the second part, which baffles me, the redefinition of an FFL in ways that aren't particularly transparent. And the reiteration that straw purchasing is illegal, which we already knew is already federal law. The problem there is that we just don't enforce it either at the state or federal level. Right. And then there's the federal bits. Now, the federal bits I actually have some time for in theory. I don't have a problem with the federal government trying to work out how to improve the background check system in the way it currently exists. And I don't have a problem with expanding definitions of domestic violence to try and prevent people from getting hold of guns and then shooting their spouse or girlfriend or what you will. It's just that I don't think these provisions have been really thought through. First, there's a weird provision in that which expands the definition of domestic violence convict of a misdemeanor, of course, because felons are already prohibited, to those with girlfriends, essentially who are in a long-term or serious relationship.
Dating partners, yes. But
then expires it after 5 years. Now, firstly, I'm not clear why we would do that, but if we believe that after, say, 5 years, people who've committed violent crimes are or should be eligible to buy guns again, I mean, maybe we should have a conversation much more broadly about that, because that's not the way we treat anyone else. If you rob a bank, we don't give you 5 years and then give you a gun back. It's weird.
It's an odd provision because it's so it expunges the record after 5 years only for domestic violence misdemeanors committed by people who against their dating partners, which one, also, they don't really define what a dating partner is. They have some vague guidelines about it, dealing with the length of the relationship and the nature of they don't really specifically say any of like how long the relationship has to be, or it's real. A lot is left up to, I guess, the courts to figure out. But yeah, anyone who is found to be in this category of somebody who's committed a domestic violence misdemeanor against a dating partner, their record is automatically expunged from NICS, the National Institute of Criminal Background Check System, after 5 years if they don't recommit a crime or break probation or anything like that. And it is odd because it does not apply to any of the other domestic violence misdemeanor convictions or any of the other prohibiting records for some reason. Even the juvenile records don't so they have sort of two things that are separate that are smushed together when it comes to juveniles. Or young, adults under 21. There's a juvenile records thing, which adds all felony and domestic violence, misdemeanor, and involuntary commitment records, juvenile records, to the NICS system. And then there's a special background check process just for 18 to 20-year-olds, which really kind of, it seems like in practice it would automatically, or in the vast majority of cases, put somebody into a delay process where the FBI gets 3 days to investigate whether there are red flags, whether there's some reason to think you might have a disqualifying record, and then gets 10 days total to look for that record before the sale can process without a decision. But the background check process goes away after 10 years, but the records don't. They all stay in the system.
Well, this is another part that I'm confused by. And I think, as with the so-called boyfriend loophole, which we just discussed, it's the product of a total lack of debate. This has been written in private. It's being rushed through. So if it is a good idea to include juvenile records, for example, and I'm open to the idea that it is, we should have had a much longer conversation about this, because the way that states treat juvenile records really varies dramatically. Some of them automatically expunge those records. Some of them allow them into court. The federal government is about to preempt 50 states on juvenile records question and include them in the background check system when evaluating eligibility for a constitutional right. And it's just going to do it in a week. You know, I'm no fan of Alexandria Ocasio-Cortez, but she does have a point on this, that this has far-reaching consequences, and we just haven't talked about it at all. Also, the inclusion of juvenile records, which apply to everyone irrespective of their age, so 18 to 20 and also 21 and above, seems to me to be a bit of a problem, because the law only amends purchasing. Yes. It doesn't amend possession. Now, is that a mistake? It could be. This was written really quickly. If it's not, what is it trying to achieve?
It's very odd.
If the idea is to prevent people who have juvenile records, because they're presumably dangerous, from having guns and hurting people with them, then do you not want to make it illegal for them to possess those guns too? So we're what? We're going to have a lifetime ban on buying a gun if you have a juvenile record,
on selling
obtained at any age, but not, on buying a gun or selling someone, but not owning one. Yeah,
it's not even, you could legally... Someone with a prohibiting juvenile record under this bill could legally try to buy one. The onus isn't on the person with the record. It's the onus is on the seller. There's a knowingly standard in there. So, it's not just, you'd have to have some reason to think the person was prohibited. But yeah, I mean, it's very odd the way it's written. I imagine that's a mistake, because why would you do it that way? It's not a grandfathering, right? It doesn't.
No, we don't do it anywhere else either.
Yeah, it's just a very odd thing. And then the changing the definition of FFL or engaged in the business in order to require somebody to obtain a license seems, the language appears to be just as vague as the previous language, except for the requirement that somebody be trying to make a livelihood off of the gun sales. That's in the previous definition. Now it's just that they're predominantly trying to profit, which opens up the idea that maybe anyone selling a gun for profit at any point might. And
I have to say, the reason this bothers me, Stephen, is that the interpretation of the previous provision is clear. Whether or not the previous provision is clear to the average person reading it, we now have 29 years of case law on what that provision means. I mean, this is obviously the product of the Brady bill, because you have to determine who has to run a background check and who doesn't, and the 1968 Gun Control Act. And so those two have intersected for 29 years, and we have a fairly good idea what it means. And the Democrats want to change it. They want to change it with so-called universal background checks too, but they also at various points have tried to change or clarify or massage what it means to be in the business. Obama tried to do this over and over again. And they've run up against a brick wall because that law has been fairly stable. And now in a bill that no one has really read or debated, suddenly it's being changed. I'm not saying there's some grand conspiracy here, but I think that makes it very difficult for people who are trying to comply with the law to feel comfortable selling a gun.
Mm-hmm.
I mean, if I had a bunch of guns that I didn't want anymore, and I thought maybe I'll go down to a gun show and I'll sell one, or maybe I'll sell one on Craigslist, and I would now worry that some court's going to come along and say, well, this what looks like a semantic change is actually a really important change, and you're going to federal prison.
Yeah,
I don't think we should be changing the law like that.
I think that's a real risk of this language change. I mean, I sold a gun and made a profit off it once. I'd built an AR, and the demand for ARs went way up in 2013, if you recall, because of concern that they were going to become banned. And I made money when I sold that AR. Under this new standard, would I be breaking the law? I don't know.
Right.
There was some speculation that they were finally going to put like a number on how many sales you could do before you needed to get a license. But it doesn't do that. It's just equally as vague as the other one, except it seems to remove the livelihood requirement. At least it removes livelihood from the definition of engaged in the business, which sounds like a lower standard to me now.
Right.
Right. I would be pretty worried that the ATF could just, go after anyone who's selling a gun and makes a profit off of it in any circumstance. I don't know. We don't know. That's the problem. And you're right. There hasn't been really any debate. And I should mention that, as I mentioned last week, Senator Cornyn John Cornyn from Texas, who's been the leading Republican in these negotiations, had agreed to come on the podcast. That got pushed back to this week, and then now it's been pushed off again. His senator says he's too busy, but he will make it up to us at some point. We'll see. But the bill's going to get passed before he comes on the show at the very least, and that's not a great sign either.
No, it's not.
So I wish there was more openness to. Yeah, obviously he's answered questions from other reporters, but I wish he would come on and do an in-depth interview on this proposal, because it's important. I mean, this stuff, like I said at the top of this section, I really think it could affect probably millions of people. Just that juvenile records part alone, in the end, has the likelihood to affect quite a lot of people. But we'll see where it ends up. If maybe I don't think they're gonna even allow any amendments to be considered during the next day or two here. So I think the text of the bill is what it's going to be.
Yeah, although it's possible the House will change it, but
could be, but probably not. They're looking to pass this as fast as they can. They don't want that coalition to fall apart.
No,
politically that's understandable, but it's perhaps not great for lawmaking, right?
Right.
But anyway, we really appreciate you taking the time. I know you're super busy because every gun news story just broke all at once here, and you're in high demand. So we really appreciate you coming on the show and giving us some of your time. Thank you so much.
Thanks for having me. I enjoyed it.
Absolutely. Wonderful. And people can head over to National Review and sign up for a subscription. I'm a subscriber. I read everything Charles writes on guns, and I recommend you do the same. So thank you so much again. We'll have to have you on down the line here to just talk about more of this, because there's going to be a lot more.
Absolutely. There always is.
Okay. I'm joined by contributing writer Jake Fogelman now to talk about another story that Jake, you wrote this week that is pretty interesting. It dovetails with the Uvalde police response, and it's about, I think, a situation that maybe a lot of people hadn't heard of, or maybe they heard about this briefly when it happened, but haven't been up to date on the details of what went down with this particular shooting in Colorado. So can you give us a little more information about what exactly is happening now?
Yeah, sure. So this is a story that hits a little close to home for me. This is happened about a half hour from where I live. About a year ago, just almost exactly a year ago, for background for listeners, a deranged guy with a anti-police animus went into a crowded shopping center in Arvada, Colorado, which is just north of Denver. with a shotgun and an AR-15. And he set out basically to shoot as many cops as he could. And he actually ended up ambushing a police officer that was responding when folks saw this guy. So very tragic situation. And he waited on scene after he killed that police officer to confront any other responding officers. Well, nearby, shopping at this shopping center was an armed citizen who had a concealed carry permit. He just happened to be there. He heard the shots. He stepped out, confronted this guy, shot him 6 times, and ended up killing him. Well, it turns out that the responding police officers that came afterwards mistook this armed citizen as the shooter or something along those lines, ended up killing him. So now fast forward 1 year, and the mother of that armed citizen is now suing that police department because some troubling details have come out about how that all transpired. That kind of calls into question the officer's actions here. They said that there's a link or a quote here from the lawsuit that kind of sums it up. It says, Mr. Hurley, who's the armed citizen, his death was not the result of a misfortunate split-second judgment call gone wrong, but the result of a deliberate and unlawful use of deadly force. So essentially, they're alleging that the responding officers didn't announce that they were police, didn't give this guy a chance to show that, hey, I'm not a threat, put my gun down, I'm not a threat. And they just kind of showed up and shot him. So kind of troubling in the wake of the Uvalde shooting. We're seeing a lot of public scrutiny on police officers responding to active shooter situations. Obviously, they're very chaotic and troubling situations, but certainly it's another, not a great incident to see.
Right. Yeah. I mean, and some of the details here are particularly concerning, just like we're learning about the police response to Uvalde and how horrendous that was, frankly. Waiting an hour to go in, like even to the point where they were disarming a fellow officer whose wife was bleeding out inside of the classroom. They stopped him from going in and took his gun away. So that's, big part of the news right now is this absurd, unthinkable response in Uvalde. And now, here's a reminder that this is not the first time that something like this has gone terribly wrong. I mean, you have a guy who saved a bunch of officers' lives, frankly, by stopping the murderer who was trying to kill them. And then in turn, they killed him. And look, obviously there's a case of mistaken identity going on here, perhaps, or almost certainly. I don't think anyone's alleging that this officer knew that this heroic concealed carrier wasn't the shooter, right? But the allegation is like they ought to have figured it out in the time frame that they were there before the shots were taken, because it was something like he watched him for something like 11 seconds, if I remember the detail in the story correctly, before taking the shot. And also, hadn't they arrived and they were hiding?
I was just going to say what adds to the kind of the troubling aspect of this is that 3 officers, there's actually a substation, an Arvada police substation at this shopping center, just because it's a high traffic area. And apparently while the initial shots, when the first officer got ambushed, broke out, 3 officers spotted the shooter, but took cover because they were concerned that he had a long gun and they only had handguns. And so they just hid in the substation while the shooting happened. And this armed citizen comes out and takes this guy down. And then they only leave once they see the armed citizen going down to secure the rifle that the bad guy dropped, obviously, once he was no longer a threat. According to the lawsuit, he was allegedly removing the magazine and clearing the chamber when he was shot. So just
that's
all around bad.
That is remarkable. You have a situation where the police are under attack and a armed civilian is the only one who actually does the proper thing, which is to try and neutralize the active shooter as quickly as possible with whatever means he has, which in this case was himself a pistol. He didn't have a rifle. And he still went to shoot and successfully subdued this attacker, only to be killed by the police he was defending. I mean, geez. Yeah, that's a rough situation. And, also one where, frankly, it's unlikely that this lawsuit succeeds. Just my personal opinion here. We don't get into personal opinion a lot, but it's, judging by how difficult it is to actually, hold police accountable for these sorts of shootings or for their own inaction, as we're seeing in Uvalde, where it's unlikely that anything significant is going to happen to any of those officers either. But it's very unlikely that this lawsuit succeeds, I think.
I tend to agree, but I will just jump in real quick. Colorado actually 2 years ago repealed qualified immunity in the state. So I think that's one thing that provides maybe a slight nugget that you could get some sort of accountability here. But I agree, the odds of it are still kind of a long shot. But
yeah, I just think that the circumstances are too murky.
Yeah,
in terms of proving that this was not. This sounds like it was on the outer limits of what's a reasonable shoot would be like.
Yeah,
because there was an active shooter. The police officer saw a man with a rifle and just assumed that he was the active shooter. That was obviously the wrong assumption and poor decision making on his part. But I think it's going to be difficult to actually hold him legally responsible for that, because it's very difficult, frankly, even without qualified immunity, to hold police responsible for these sorts of incidents. It just is. That's just the reality everywhere in the United States, not just Colorado or Texas or wherever, but that's how things work. And I think it's unfortunate too, because you got two high profile now incidents where the police were absolutely derelict in their response to a active shooter, and it paints a very negative light on law enforcement when, there are many cases where police do the proper thing in responding to these sorts of shootings. Even just the hospital shooting that occurred after Uvalde is a perfectly good example of that. They actually went in immediately and confronted the shooter, and the shooting was over within 30 seconds of them arriving.
Right.
And that's a fairly common story. These sorts of stories are less common, but they're so tragic and horrible, and there's such a lack of consequence for the people who made the poor decisions that it's something that we have to talk about.
No, absolutely, and it's worth noting this officer that shot the armed citizen was cleared of any criminal wrongdoing by the district attorney in this case. So there's no legal ramifications other than whatever the long odds are of this lawsuit. So just for the listeners' awareness. Right.
Yeah. And that's a good point to make. But he did resign, I guess, this officer.
Yeah.
Although isn't there a comment about the police department would love to have him back?
Yeah. Some local reporting here in Colorado uncovered a statement that said we would take him back if he wanted to come back, because I guess he resigned of his own volition after the investigation into his shoot. So
yeah, see, that's what I think what I'm talking about. Like, often these police officers don't even lose their jobs when they make horrible mistakes, or wouldn't lose their jobs, or would be welcomed back if they resigned. It's the same thing in Uvalde. All those officers are still, as of now, in the police department. They stood in the hallway for an hour while children were slaughtered, but that's not a fireable offense, apparently.
Right.
So it just makes people, makes you wonder what is a fireable offense.
Right.
And that's the hard part. Obviously, you don't want to put law enforcement in a situation where they're constantly being second guessed about everything, but there also needs to be some sort of some level of accountability here. Right.
Some things are just obvious. Yeah.
Yeah. Like, geez. But anyway, thank you so much for writing this one up. I think it's one that's been floating around on social media. I've seen some references to it, but there hasn't been a lot of reporting on it, which is what we exist to do, right, at the Reload, is to sort of surface some of these lesser known stories that are still very important and relevant.
Right.
And I think you did a good job with this one on that front. But that's all we've got for this week. Make sure you head on over to thereload.com if you want to buy a membership. So you can get exclusive access to this podcast a day early, or have the opportunity to come on the show. We had, I think I mentioned this earlier, we have Mary Catherine Ham, who's a Reload member, on our episode last week. And hopefully we'll have some more of those in the coming episodes as well. But the only way you can qualify for that is if you buy a membership, and that will also get you exclusive access to hundreds of posts, analysis pieces, and exclusive stories that you cannot get literally anywhere else. So head on over to thereload.com and check out our membership options today. And also, if you've made it this far in the podcast, it might indicate that you like this show. And you should head over to go on to whatever app you're listening to this on and give us a rating and a review. That really helps spread awareness of the show and all the algorithms and so forth. I have no idea how those work, but I believe that ratings make a difference. I don't think anyone really knows how they work, but outside of the companies. But hey, give us your feedback. We'd really appreciate to hear it. But that's it for this week. We will see you guys again next week.